For 40 years on the bench, I thought I had seen every kind of arrogance a courtroom could produce. I had watched wealthy men walk in with lawyers who cost more per hour than some people earned in a week. I had seen powerful families treat the law like a locked door they had already purchased the key to. I had watched defendants lie, threaten, beg, collapse, and smile, as if the truth were just another obstacle money could remove. But on the morning of March 6th, a billionaire landlord looked directly at me in open court and said 4 words I had never heard before. "I own you, Judge." For 3 seconds, I could not speak, not because I was afraid, because for the first time in a long time, someone had said out loud what powerful people usually only imply. Across from him sat a 68-year-old woman in a blue wool coat and white gloves. Her name was Marlene Carter. She had no attorney, no legal team, no driver waiting outside, no expensive folder full of arguments. All she had was a plain manila folder. Inside it were 11 months of careful work, printed emails, certified letters, rent receipts, neighbor statements, permit records, and handwritten notes she had made at her kitchen table alone. She was fighting to keep the apartment she had lived in for 22 years, and the man trying to remove her was worth $2 billion. That morning, the question was simple. Would money decide what justice meant? Or would one woman with a folder prove that a courtroom still belonged to ordinary people too? Marlene Carter had lived in the same apartment for 22 years, 3 rooms.
Same building.
Same neighborhood, same corner store where the owner knew her by name. She had raised 2 children there, mostly on her own. Her son became a teacher in the Bronx. Her daughter became a nurse in Philadelphia. Marlene herself had worked for the Postal Service for 31 years, walking her route through rain, snow, heat, and every kind of morning New York could throw at a person. She was never late with rent, never caused trouble, never treated the building like anything less than home. Then Victor Langford bought the property. Victor Langford was 44 years old, 4th-generation wealth, owner of a real estate portfolio spread across several states. His grandfather had built the family company. His father had expanded it. Victor inherited it at 30 and spent the next 14 years multiplying what others had created before him. Business magazines called him brilliant. Investors called him aggressive. Tenants called him something else. Within 60 days of buying Marlene's building, Victor's company sent eviction notices to nearly every long-term tenant. No rent violations, no complaints, no damage. No cause. He wanted the building empty. He planned to gut it, renovate it, and reopen it as luxury apartments starting at $6,000 a month. A glossy sign had already been placed in the lobby showing exposed brick walls, a rooftop terrace, a fitness center, and lounge furniture under string lights. That sign went up while Marlene was still sleeping in the same bedroom she had slept in for 22 years. She told me later that it took her a full week to understand what that sign really meant. She was not a tenant to them. She was an obstacle. Most people would have left, not because they were wrong, because fighting someone with that kind of money feels impossible before it even begins. But Marlene Carter did not leave. She began building her case. Every email she sent to property management. She printed every phone call she made. She logged with the date, time, and name of the person who answered, or more often, the person who did not. Every certified letter was tracked, every rent receipt was copied. She pulled the building permit history from the city's public records database, teaching herself how to use it late at night, with reading glasses on and her folder open beside her. She collected statements from 11 neighbors, people who had also lived there for years and had received the same notice. Her timeline was clear. Victor bought the building in October. Eviction notices went out in December. Renovation permits were filed in February. The luxury rental sign appeared in March. By the time she placed that folder on the plaintiff's table, Marlene had done what many attorneys fail to do. She had made the truth impossible to ignore. Victor arrived with a driver, a black SUV, and a legal team that billed in 6-minute increments. His lead attorney was Simon Vale, a polished corporate lawyer with the kind of confidence that fills a courtroom before he says a word. He moved to dismiss the case immediately on procedural grounds. His argument was sharp, technical, and designed to end the hearing before Marlene ever got to speak. "I denied the motion," Simon blinked. He was not used to that word arriving so quickly. Then I turned to Marlene. Mrs. Carter, you are representing yourself today. This court will give you time to present your case fully. There is no rush. She looked at me like someone who had spent 11 months being ignored and was not sure yet whether to believe me. Then she opened her folder. For the next 40 minutes, she did not plead. She did not perform. She did not ask for pity. She simply told the truth, page by page. She showed her 22-year rent history. Never late, not once. She showed the emails no one answered. She showed the certified letters. She showed the eviction notice. She showed the permit dates. She showed the luxury renovation advertisement that had gone up while tenants were still living there. She showed statements from neighbors who had already been forced out or were packing to leave. Her voice stayed steady. Her hands did not shake, and while she spoke, Victor Langford looked at his phone. Not once during those 40 minutes did he look at her. When Marlene finished, the room was quiet. Then Simon Vale stood again and began building his wall of law. He spoke about property rights, no-fault evictions, market conditions, renovation timelines, statutory authority, legal ownership. He was accurate. That was the uncomfortable part. The legal framework he described was real. Victor had rights as the owner, but having the right to do something is not the same as being right. I let Simon finish. Then I asked to hear from Victor himself. Victor stood slowly, adjusted his jacket, and spoke like a man who had explained this same thing to many people and had never once been seriously challenged. He talked about investment. He talked about market value. He talked about the responsibility of ownership. I asked him whether any of the tenants had violated their leases. He said no. I asked whether Marlene Carter had ever missed rent. He said he did not personally manage individual tenants. I asked him what the difference would be between current rent and the projected luxury rent after renovation. He gave me a number. It was more money per year than Marlene Carter had earned across much of her postal career. I let the number sit in the room, then I told him something he clearly did not expect. The law you are citing exists, I said. This court recognizes that. But recognizing a legal framework and approving what someone uses it to accomplish are two different things. Victor looked at me with mild surprise, not anger yet. More like someone had found a locked door in a hallway where every door had always opened. His attorney leaned toward him and whispered. I could tell Simon was telling him to stop talking. Victor ignored him. He placed both hands flat on the table and looked directly at me. Your Honor, he said calmly, I own over 60 properties in 4 states. I have more legal resources available to me than this court sees in a year. I know precisely what the law requires and precisely what it does not. Then he paused. His eyes stayed on mine. I own you, Judge. 3 seconds, that was how long the courtroom stayed frozen. His attorney went pale. The court officer